The Lawfare ledger in Fulton County, Georgia, has just hit a catastrophic deficit. Today, Judge Scott McAfee has dealt a decisive blow to the disgraced District Attorney Fani Willis. In a ruling that signals the final financial liquidation of her failed prosecution against Donald Trump, the judge has denied her attempt to block a massive recovery effort. We are talking about nearly $17 million in attorney fees and costs that Trump and his 18 co-defendants are now cleared to pursue. This isn't just a legal defeat, it's a fiscal nightmare for Fulton County. After the high-profile election interference case collapsed late last year, the accountability has shifted from the defendants to the prosecutor's office. Today, we audit the cost of a prosecution that many are calling a disaster of historic proportions. The ruling is particularly stinging because Judge McAfee made it clear. Fani Willis no longer has a seat at the table. Since she was disqualified from the case in December 2024 due to her romantic relationship with Special Prosecutor Nathan Wade, her office has no legal basis to intervene in the fee litigation. The state is now represented by a temporary DA, leaving Willis on the sidelines as the $17 million bill comes due. As an auditor, I see an organization, the Fulton County DA's office, that has lost its operational authority while its liabilities continue to balloon. I'm Camilo Motato, reporting for THU News. As a certified public accountant, I look at professional malpractice and its subsequent financial penalties. In any corporate audit, if a manager is disqualified for improper conduct and their actions lead to a $17 million loss, that manager is held personally and professionally liable. Today, we are auditing the Fani Willis ledger. We are looking at a case where the prosecutorial discretion was so compromised that it triggered a 2025 Georgia law allowing defendants to recover every cent of their legal defense. Trump alone is seeking $6.2 million. This is a total loss of assets for the credibility of the Fulton County justice system. Let's examine the legal mechanism that is driving this $17 million claim. The dispute centers on a new 2025 Georgia law specifically designed to protect defendants from lawfare. The statute allows for the recovery of attorney fees if a prosecutor is disqualified and the case is subsequently dismissed. As a CPA, I view this law as a mandatory refund policy for bad faith litigation. Fani Willis argued that this law was unconstitutional, but Judge McAfee has declined to halt the process. This creates a sovereign risk for Fulton County. While Willis is out, the county itself has been granted permission to intervene because they are the ones who fund the DA's office. The taxpayers of Georgia are now facing an unfunded liability created by the personal conduct of their elected official. Donald Trump's legal team, led by Steve Sadow, is not wasting any time. They have characterized this as a lawfare case, where the disqualification for improper conduct bars Willis from any further participation. In accounting terms, Trump has moved from a defendant to a creditor. He is seeking a massive settlement from the very office that tried to destroy him. This $6.2 million request isn't just a number. It's a penalty for prosecutorial overreach. The judge will now begin the reasonableness audit, evaluating whether these fees are justified under the statute. Given the complexity and the duration of the multi-year battle, this process could take months. But the direction of travel for the money is clear. It's flowing out of the county coffers and back to the patriots Trump says were targeted. To understand why Fulton County is now facing a $17 million account payable, we have to audit the root cause, the professional and personal collapse of Fani Willis. In December 2024, Willis was officially removed from the case after it was revealed she had a romantic relationship with her hand-picked special prosecutor, Nathan Wade. As a CPA, I track related party transactions. In the corporate world, if a CEO hires their romantic partner as a high-paid consultant and uses company funds for joint vacations, that is a textbook case of fiduciary breach. Willis didn't just prosecute Donald Trump, she created a revenue stream for a private attorney with whom she shared a personal life. This conflict of interest was the poison pill that liquidated the entire case. When Judge McAfee disqualified her, he wasn't just stopping a trial, he was marking her entire operation as non-performant. One of the most significant audit findings in McAfee's recent ruling is the status of the Fulton County DA's office. The judge noted that the state is already represented by a temporary district attorney appointed after Willis's removal. This means that Fani Willis is effectively a terminated asset within this litigation. She tried to intervene to block the $17 million in fees, arguing that the 2025 law was unconstitutional. But the court's message was clear: your legal standing has been revoked. In accounting, when a manager is removed for improper conduct, they lose all signatory authority over the firm's future actions. Willis is now watching from the sidelines as the temporary management decides how to settle the massive debts she left behind. The road to this $17 million disaster was paved with failed appeals. In September 2025, the Supreme Court of Georgia declined to review Willis's removal. This was the final notice for her career as the lead on this case. As a professional auditor, I see this as a loss of recourse. Once the highest court in the state refuses to hear your appeal, your goodwill as a prosecutor is zero. The Prosecuting Attorneys Council of Georgia was forced to identify a replacement, and the case was eventually dropped. This creates a chain reaction of insolvency. The case is dropped, the 2025 law kicks in, and the defendants, the patriots as Trump calls them, present their bill. Fani Willis's attempts to claim that her disqualification wasn't the cause of the dismissal is, in my professional opinion, a material misrepresentation of the facts. While Fani Willis was denied the right to intervene, Fulton County itself was granted permission. Why? Because the county is the funding source. They are the ones who ultimately have to pay for Willis's mistakes. In accounting, we call this indemnification risk. The taxpayers of Fulton County are being forced to indemnify the defendants for a prosecution that failed due to the unethical conduct of their elected official. Fani Willis's hope that a future prosecutor would have the courage to continue the case has been met with a cold reality. No one wants to touch a toxic asset. The county is now in damage control mode, trying to mitigate a $17 million hit that could trigger local tax hikes or budget cuts in essential services. Let's perform a forensic breakdown of the most significant line item in this litigation: Donald Trump's request for $6.2 million in attorney fees. For a professional auditor, this isn't just a random number. It represents thousands of billable hours, expert witness fees, and the defense overhead required to fight a multi-year RICO indictment. In accounting, when a project is canceled due to negligence by the lead contractor, the district attorney, the client, Trump, has the right to be made whole. Trump's lead attorney, Steve Sadow, has been meticulous in recording every movement of this Lawfare case. By pursuing this $6.2 million, Trump is essentially issuing a refund demand to the taxpayers of Fulton County for a prosecution that Judge McAfee has effectively ruled was tainted by improper conduct. The reason this $17 million total claim is even possible is a specific piece of legislation: the 2025 Georgia Lawfare Protection Act. This law was a direct legislative response to the Willis-Wade scandal. It mandates that if a prosecutor is disqualified for a conflict of interest and the case is later dismissed, the defendants are entitled to full reimbursement. As a CPA, I view this law as a statutory guarantee of quality control. It imposes a massive financial penalty on the state for, quote, product failure in the justice system. Fani Willis tried to argue that this law was, quote, unconstitutional, but her protests were dead on arrival. The law acts as a financial firewall, ensuring that prosecutors who, quote, couldn't keep their clam in their pants, as the report bluntly puts it, face the fiscal consequences of their personal choices. This is, quote, accountability in its purest, most expensive form. Trump's attorney, Steve Sadow, celebrated the ruling on social media, stating that the disqualification for, quote, improper conduct bars Willis and her office from any further participation. From a, quote, risk management perspective, Sadow has executed a perfect counterclaim strategy by shifting the focus from the, quote, alleged conspiracy to the, quote, actual misconduct of the prosecutor. The defense has turned a criminal liability into a, quote, financial asset. The $17 million is now an account receivable for the defendants, and the burden of proof has shifted to Fulton County to explain why these fees shouldn't be paid. The next phase of this litigation is what we call the reasonableness test. A judge will now evaluate the $17 million in claims, including Trump's $6.2 million, to ensure the fees aren't inflated. As a professional auditor, I know this process will be grueling. The court will review billing records, hourly rates, and the necessity of every motion filed. However, because Fani Willis was disqualified for improper conduct, the defendants have the presumption of merit. Fulton County, now acting as the insurance carrier for Willis's mistakes, will try to negotiate these numbers down. But at the end of the day, the insolvency of the prosecution is so total that any reduction in fees will be a minor accounting adjustment in a massive $17 million defeat. As we conclude this forensic audit of the Fulton County disaster, we must address the ultimate residual interest: the taxpayer. Judge McAfee granted Fulton County permission to intervene in the fee litigation for one reason. They are the guarantors of the district attorney's office. If the court approves the $17 million in reimbursements, it won't be Fani Willis or Nathan Wade writing the check. It will be the residents of Fulton County. In accounting, this is a contingent liability that has now been recognized on the books. While Willis argued that the 2025 law was unconstitutional, her failure to block the litigation means the county must now prepare for a massive cash outflow. For a local government, a $17 million unplanned expenditure is the equivalent of a fiscal emergency. This could lead to budget reallocations, effectively making the citizens pay for a prosecution that a judge has ruled was tainted by improper conduct. Donald Trump's rhetoric following the Georgia Supreme Court's decision has been a masterclass in reputational audit. He told reporters that what Willis did to innocent people, patriots that love our country, was an attempt to destroy them, and he even suggested she should face jail time. From a social capital perspective, Willis has suffered a total impairment of goodwill. By indicting 18 co-defendants alongside Trump in a case that ultimately collapsed due to her personal choices, she has created a legacy of litigation that will haunt her office for years. The $17 million in fees is being framed by the defense not just as a reimbursement, but as reparations for lawfare. Trump's $6.2 million claim is a symbolic invoice for justice, served to an office that, according to the court, lost its way. The final audit of the Fani Willis era shows a bankruptcy of prosecutorial integrity. We have a district attorney who was disqualified for a conflict of interest, a special prosecutor who was paid with public funds while being romantically involved with his boss, and a case that was eventually dropped because no one else would touch the toxic assets it left behind. As a CPA, my verdict is that this case was insolvent from inception. The 2025 Georgia law has acted as the auditor of last resort, ensuring that the financial burden of legal misconduct falls back on the institution that allowed it to happen. Fani Willis may hope for courage from her successors, but in the world of the law, courage cannot override a material breach of ethics. But I want to hear from you. Do you think $17 million is a fair price for Fulton County to pay for this lawfare? Or should Fani Willis be held personally liable for the costs? Is Trump's $6.2 million invoice a justified refund for the years of litigation? Let me know in the comments below. Your perspective is the only audit that matters when the justice system goes into default. I'm Camilo Motato, certified public accountant for Thu News. Thank you for joining me for this deep dive into the collapse of the Georgia case. Subscribe to stay ahead of the numbers, and stay safe.